Next bill we have up is Chair Mariani, House File 3975. Members, this bill received a lengthy informational hearing in Public Safety on March 4th, and so today we'll be hearing the bill in Judiciary and voting to send it to the General Register. Chairs have discussed this between each other. That's going to be the motion. And Representative Mariani, do you want to move House File 3975 to General Register?
Mr. Chair, that is my motion today.
Thank you. Please begin.
Mr. Chair and members, as the Chair shared, we had a extensive information hearing on this in Public Safety. This bill is properly, however, housed here or placed here within the jurisdiction of this committee. This has to do with judiciary procedures, so it's proper for us to be moving from this point. House File 3975 expands access to existing law permitting a petition for post-conviction relief to include when a petitioner is facing immigration removal as a result of a conviction that came about by either relying on incorrect advice or having gotten no advice from counsel about immigration consequences. Post-conviction relief is a way to challenge the legality of a constitution or constitutionality of criminal convictions after the period for direct appellate relief has expired, or once all appellate remedies have been exhausted. It's a remedy that's available for all people who have been convicted of a crime in Minnesota. Members, it's been a longstanding principle in Minnesota that when people are wronged by our criminal justice system, and it does occasionally happen, that people have an opportunity to seek justice. PCR, post-conviction relief, is not an automatic relief. It simply provides an opportunity to make a case for relief by having a court review the context of a conviction. It gives a person essentially a day in court for a high-stakes outcome. This bill provides a sixth exception to the 2-year time window from conviction within which to petition the court. This bill does not prevent a federal decision on removal or deportation. It simply allows a Minnesota conviction to be reconsidered and to make that reconsidered outcome available for deliberations in federal court. So members, here to quickly share why it's important to expand on this Minnesota principle today. In other words, how it can positively impact the lives of Minnesotans. And to answer questions are Ms. Kai-Ying Yang and Professor Linus Chan.
Thank you. Welcome to the committee. Please introduce yourself to the record.
Good morning, Chair Lesh and members of the committee. My name is Kai-Ying Yang, and I am the Director of Programs and Partnerships at the Coalition of Asian American Leaders, also known as CAL. I'm also here on behalf of a coalition of organizations working on expanding access to justice through post-conviction relief. We are working together to stop the detention and deportation of former refugees from Southeast Asian and African countries. The PCR Coalition has mobilized more than 26 organizations to endorse this bill. In addition to the community organizations, we have also we have the support of 3 unions and 7 government entities, including 3 county attorney offices. And if you look in the handout that was in your folder, I think, you'll see who those organizations are. Recently, there has been a confirmation that there will be a significant increase of deportation of Hmong, Lao, and other ethnic people with removal orders to Laos. This will have a devastating impact on hundreds of families and perhaps thousands of individuals related to those families in our state. This includes spouses, siblings, parents, and children of those deportation orders, those with deportation orders. In the state of Minnesota, we are home to over 160,000 Southeast Asians, and more than half of them are Hmong, who came to the U.S. as refugees fleeing political persecution from their country of birth and or their parents' country of birth. We cannot ignore this crisis, and neither can you. Most of the Southeast Asians with deportation order came to the U.S. as young children. Growing up in Minnesota, they can barely speak the language of their parents' home country and have no familial relations in the country, in those countries. All have already served their sentences and are being persecuted for crimes from decades ago. One case was 30 years old. Most were in their teens, poor, unable to afford private attorneys, and took plea deals, not knowing that they had agreed to a life sentence of deportation. Immigrants in Minnesota, such as other refugees, Somalis and Liberians, face similar consequences. For instance, despite the recently passed Liberian Refugee Immigration Fairness Act that gives reprieve from deportation for Liberians of on temporary status, many Liberian refugees will benefit from this PCR bill if it passes. Today, these refugee and immigrant communities have family, U.S. citizen children, and strong economic and social connections to Minnesota. Our community members deserve redemption and a second chance like any other American. The current time limit on filing petitions for relief leaves out a community who deserve to challenge their convictions but were not informed of the opportunity to do so in a timely manner. House File 3975 addresses this problem, and that is why we are here to ask for your support. I want to conclude my statement. I want to close by telling the story of Peng Vang, who testified at Chair Mariani's committee the other day. She is an impacted family member who lives in Maplewood, Minnesota with her husband and 5 children. Peng is a nurse and pursuing a doctorate as a primary care nurse practitioner. Her husband came to Minnesota in 1989 at the age of 9 and has since called Minnesota his home. His father served in the secret war in Laos, a war the U.S. CIA organized and recruited Hmong tribesmen as foot soldiers during the Vietnam War from 1960 to 1975. More than 50,000 Hmong people lost their lives. When his family arrived as refugees, they struggled not only with adjusting to a new world, but also dealing with grief due to the loss of family members in the genocide conducted by the Laotian government. They also struggle with racism and bullying in this new homeland. In the late 1990s, at the age of 17, her husband made a mistake and entered into the extended juvenile jurisdiction program. He was not aware of what this meant. Even though he successfully completed the 18-month program, a minor violation triggered 18 months in 18-month adult sentence. It has been over 20 years since the incident, and her husband served his time and changed his life around. However, he has a removal order to be deported to Laos at any moment. Now he has a degree in computer networking and software engineering. He owns a information technology and software consulting business. He is a loving husband, father, son, and mentor, and community volunteer. Peng's story represents many of our community members' stories. We are asking you to consider giving people like Peng's husband a second chance so that our families can stay together and continue to make a positive impact in our community. Thank you for the opportunity to testify.
Thank you for your testimony, Ms. Young. Go ahead and introduce yourself for the record.
Thank you, Chair Lesh, representatives. My name is Linus Chan, and I teach at the University of Minnesota Law School. I'm also an immigration lawyer, and my students and I represent people held by immigration detention. I've also been asked to testify here because I've been working with the Post-Conviction Coalition on drafting this language that's in front of you. I want to be clear, the post-conviction statute can seem daunting and technical, but this change does not, as Chair Mariani mentions, does not change the substantive basis of the law. All it does is increase access to allow those to file post-conviction petitions after a 2-year period. The current statute in the books now already recognizes 5 separate ways in which the 2-year limitation has exceptions. All 5 of those exceptions recognize that there is good reason why someone may not have filed a post-conviction petition within the 2-year period as they have. Some of them have to deal with being ill, some have to do with a change in law. What we are asking today is this bill simply recognizes that because immigration consequences do not have its own statute of limitations, that immigration consequences, otherwise known as an actual consequence of a criminal conviction, can happen long after the 2-year period, it is a good reason to allow someone to go back and re-examine why and whether or not their conviction was either unconstitutional or illegal. That is the totality of this statute. It sounds technical, but in its heart, is simply giving additional access to people to have their claims heard in court. Thank you.
Thank you, Professor Chan. Are there other folks in the audience, members of the public, who are here that wish to be heard on House File 3975? Seeing none, then we'll move to member questions. Representative O'Neill.
Thank you, Mr. Chair. I have kind of a technical question. So I noticed there's not a fiscal note, and the next stop is the GR, the General Register. So when we had heard this before, because I'm on public safety with you, the fiscal note there basically had said something about that the court was unable to really estimate the change because of the lack of clarity of the language of the bill. So I'm wondering, do we have a updated fiscal note, and it has that language? Were they able to clarify the language and have better understanding of what's happening in this bill so that we know, do we have a fiscal impact to the courts or not?
Mr. Walls?
Mr. Chair, Representative O'Neill, when the bill was first introduced, I read the bill and interpreted that it would not have an impact based on discussions I've had with the courts on the number of cases that are required to drive the addition of a judicial unit. I have since recently thought that perhaps that was incorrect and submitted a request for a fiscal note, but since the bill was introduced recently and the fiscal note request was put in recently, it is not complete yet. I have put an expedited date on that, and if a fiscal note does come back in, it would be pulled from the General Register and referred to Ways and Means.
Representative O'Neill?
Thank you, Mr. Chair. I just want to make sure that we handle with procedural things. And, we had issue yesterday with a department bill coming up, and I just want to make sure that we're going at a pretty fast pace. So I just want to make sure that we're doing this correctly and accounting for all the money. So thank you, Mr. Chair.
Thank you, Representative O'Neill. However, this bill was introduced last year. Is that correct?
That's correct. Mr.
Okay.
Chair.
So I want things to be correct as well. However, I had a UAV bill moved off the floor that had been on the General Register for a year. And then the Department of Public Safety came in last week and said, looks like we got a price tag on it. So as far as I'm concerned, when things have been sitting out there for that long, and any agency or the courts suddenly decides at the last minute that there's a price tag on them, as far as I'm concerned, they can eat that because they weren't on top of it. But reasonable minds may disagree about, well, they're still advisory. Fiscal is still advisory. Representative Barr.
Thank you, Mr. Chair. And I guess it could be the bill author or any one of you three could probably, just more of a clarification, I suppose. So this would basically remove the 2-year limit forever. So in the case of like Mr. Vang that you referenced, this is 20 or 30 years ago, he would be able to now apply for the removal of the eviction order. Is that apply for the review of that, right? Am I understanding that right?
So let me,
Chan.
yeah, so Chair Lesh and Representative, to answer the question, it doesn't remove the 2-year limitation at all. The 2-year limitation is still there. With Mr. Vang, it would actually require a little bit on timing because there is both under subsection C of the current statute, there's still going to be a 2-year window in which someone has to file the petition. So just as an example, if we were to take Mr. Vang's situation, if he gets put into removal, has to report for removal or detained for removal, he would then have 2 years to file that petition. If he doesn't do it, then he's also barred based on time limitations. So while the triggering event, which is the place and removal proceedings, being detained for removal or having to report for removal, those would then start another 2-year clock. So to answer your question, it would not remove it in perpetuity, and he couldn't just sit on a claim like that. He would have to come forward within a timely manner.
Representative Albright.
Thank you, Mr. Chair. Chair Mariani, I'm looking at the additional language on 2.6 through 2.9, and the proceedings that have been discussed are triggered by and forgive me if I'm saying this incorrectly, you're an individual's immigration status, or not?
Mr. Chair, and Representative Albright, immigration law is pretty complex. Someone has
Professor Chan.
Professor Chan.
So there is no requirement on immigration status at all in the bill. It's agnostic to status. The way that status might come up, however, is if you are a U.S. citizen, you can't be placed in removal proceedings, right? You can't be detained for purposes of removal, and you can't be required to report for removal. So in that sense, that's the only time that status ever comes up. But there is potentially a situation where someone, and this has happened quite a bit because as Representative Mariani has mentioned, immigration law is complicated. So could be situations where someone thinks they are U.S. citizens, believes that they are U.S. citizen, and for the most part, even be issued a passport, a U.S. citizen passport, which we've seen, and then only later on have found that that has been deficient for some reason, and then they are put in proceedings. At that point, the issue, the triggering, the removal proceedings, detention for removal, or report for removal, would then allow them to then file for an additional review. So while it's agnostic, the statute on the actual status, it is possible for someone to ultimately be a U.S. citizen to make this challenge, and this might be particularly relevant for those since now the U.S. government is taking more seriously the denaturalization route. That may come up, which is why it's important that this statute itself does not require anything on immigration status, whether it's a U.S. citizen or not.
Mr. Chair, thank you. So let me just maybe ask a clarifying question. And again, I apologize, this is not my marquee subject matter. But with regard to someone who has sought refugee status or asylum in the United States, and for purposes of drawing a distinction, is found to have, let's say, a speeding ticket.
Sure.
And by virtue of a speeding ticket, goes to court and pleads guilty, but I forget the process, is put on probation for 6 months, and if you don't, an Alford defense, you don't need to put it on your record. It's vanquished if you're good for 6 months. Would that trigger this type of proceeding?
So, if I
Professor
may,
Chan.
Chair and Representative, it's unlikely for several reasons. One, a speeding ticket itself is not a criminal conviction, so a speeding ticket wouldn't trigger this at all. And then specifically, this really looks after crimes that have direct consequences for removal. So speeding tickets or other, what even could be considered a certain number of things that are considered not criminal, or even some crimes don't necessarily trigger the removal aspect for people. And then finally, for someone who is, and it's unclear by your question, but if someone is someone who's seeking refugee status in the United States and they don't currently have any sort of legal status, the reason why this will not likely be directed toward that person is because the criminal conviction is not what is causing them to be removed. They're causing them to be removed simply for not having status. So the fact that they're not getting immigration advice about the criminal status is not likely what would drive this bill going forward.
Thank you, Mr. Chair.
Representative
Chair Lesh and Representative
Oh,
Mark.
I got it. Forget it. Representative Robbins. You want to go last, right? Well, Representative O'Neill is next. Okay, forget both of you. Representative O'Neill.
Thank you, Mr. Chair. I just am confused because when we had the conversation back and forth, you had said that this language had been out for, since last year. But if you look at when it was actually introduced, this bill was introduced on March 2nd, which is only 9 days. So I'm assuming this is either a clone of the exact same language or this is a different language than what we had talked about previously. Can the author just clarify, since this was just actually introduced 9 days ago, not last session?
Chair Mariani.
Mr. Chair, Representative O'Neill is correct, and I'm going to lean on council to talk about the differences between the two bills.
Okay. Sorry. Mr. Johnson?
Mr. Chair, Representatives, I don't have a copy of last year's bill in front of me. The language is different. The substantive impact of the two bills is nearly identical. The language here is slightly narrower than the language that was in last year's bill.
So, Mr. Chair, so I'm assuming by narrower, we mean that maybe it's more clear and it's a little bit easier for the court to decide if there's a fiscal impact or not. Because when we had a different bill, in fairness, last session compared to this bill. So I'm just trying to get clarity about the fiscal note, which I know that Mr. Walls had already discussed, but.
Mr. Chair, this is actually an important question because our attempt this year was to be able to narrow the impact, which would have a direct bearing on the fiscal note. But I'll ask Dr. Chan to comment.
Professor Chan?
The first iteration of the bill was actually a wider bill that did not restrict it specifically to removal. It would have been a wider requirement for any number of immigration consequences. So this bill is narrower in impact, not just in clarity. There is, of course, always an attempt for clarity, but that's not what the difference between this bill and the bill that was introduced last year.
Representative O'Neill?
Thank you, Mr. Chair. And that's sort of my point is, although they're similar in the, maybe similar in the net effect, but I remember the other bill being much more broad. So I just wanted to get that on the record that this language has only been out for 9 days. And I do appreciate what Mr. Walls said, that if we do have a fiscal note that comes back, it'll be pulled off the GR, because that would be of a great concern. We don't want to send it out without at least discussing the fiscal impact to the courts.
Representative Robbins?
Thank you, Mr. Chair, and I'm sorry I would happily defer to my colleagues, so I'm sorry. So I'm sorry I don't have the benefit of having sat through the public safety hearing, and so just for my own making sure I understand this. Basically, this is triggered by someone being given notice of a removal or going to be removed based on, but the basis of the removal notice is a criminal conviction. Is that correct?
Mr. Chan?
Thank you.
Chair Lesh and Representative Robbins, yes, it's essentially removal that is based on the criminal conviction at issue.
Thank you.
Robbins?
Thank you, Mr. Chair. And so could you sort of just summarize for me what types of crimes would trigger the removal notice?
Professor Chan?
It's extremely broad. Some crimes, there is a broad category known as crimes involving moral turpitude, and that could be an entire course. It can be extremely broad. But common ones can include things like drug possession, even shoplifting can count as crimes that are based for removal.
One more. Thank you. This is helpful. And finally, so what this bill does is a person could be, based on a conviction, deported or given notice of that at any point, but you're saying now under this bill, what's changing from how things currently function is if they get that renewal, they would now have a 2-year time to file this petition saying they didn't get proper notice. Is that the intent?
Professor Chan?
Let me make sure I understand. The current way that it runs now is if a person is put into proceedings and the conviction is more than 2 years old, there is no clear method for them to get a post-conviction relief based on the time bar. This would allow them a 2-year window to file something that the court could consider, yes.
Thank you. Thank you.
Thanks. Chair Liebling?
Mr. Chair, and thank you very much, and Representative Mariani, thank you for bringing this. I, in my previous life, worked as a criminal defense lawyer, and probably, who knows, maybe for somebody who would need to avail themselves of this, because I'll tell you, immigration law is very complicated, and most defense attorneys, I mean, I think now they probably are more schooled just because of everybody's more aware of the possible consequences to people's immigration status or to their continuing to be in the United States. But I have to say that many attorneys didn't and maybe even don't understand the immigration consequences and certainly don't do a deep exploration of the, whether somebody's a citizen or exactly what their status is. So, often in this committee and in other committees, we talk about due process. Well, in law school, my professor used to say, due process depends on what process is due, right? And I would say that if we're concerned about justice and fairness, that this is an extremely reasonable provision. This doesn't give anybody any free get out of anything. It merely gives them an opportunity to have a day in court when they find out that something that happened maybe a very long time ago is now going to have a severe consequence that they or their then attorney never thought about or never knew could happen. So I think this is a very necessary bill. Personally, I would think, in the future, I'd like to see this be even broader because there are other collateral consequences other than immigration consequences that can be impacted in this way. As crimes began to, collect more collateral consequences, this became more of an issue. But I think this is a very, very necessary safety valve, and I thank you for bringing the bill.
Representative Muller.
Thank you, Mr. Chair, and I'm sorry I was out presenting a bill in another committee, so I didn't hear the discussion, but I don't think this has come up so far in this committee. So just so members are aware, this 2-year time bar is a relatively new function in statute. There used to not be any time limit at all on the filings of these post-conviction petitions, and we talked about this in the Public Safety Committee. I don't remember exactly what year it was, but staff had looked it up for us, but the 2-year time bar is fairly recent. So folks that didn't know of these immigration consequences really had no incentive. 2005 is what I'm hearing, but really didn't have an incentive to seek post-conviction relief because there was no, the time bar. And once that time bar was added, then it creates an added sense of urgency for these folks. Thank you.
Last comment question from Representative Herr.
Thank you, Chair Lesh. And Representative Meyer, I just wanted to say thank you for bringing this bill forward. I had a quick question for the professor, and I wanted to just make the committee aware that, so we have a very large foreign-born adoptee population in the United States. In Minnesota, we're one of the largest in Korean-born adoptees. I recently was made aware in the past year that there were Korean adoptees who thought they were citizens. I think this touches on the professor's point about the fact that they thought they were citizens, that their parents finished the paperwork to make them citizens, and then they might have had some small thing, possession of drug or something that young people often get themselves into, and then they have removal orders as well because of the change in immigration, and we have actually had deportation of our foreign-born adoptees. And I just wanted to make sure that this bill also covers those individuals. And if you could just confirm that for the committee, that would be great.
Professor Chan.
Chair Lesh, Representative Herr, there's no reason why this bill wouldn't cover someone in that situation. It is just a good example of why someone would not have gotten advice at the time because they thought they were a U.S. citizen.
Thank you for that question. Representative Herr, do you have another one?
Just a quick follow. So thank you, Chair Lesh and the testifiers and Representative Mariani. I think that a lot of times when we hear certain issues, we sort of associate it with a certain group of people. And I just wanted to make sure that we are very clear in the fact that this is not a specific issue to the Southeast Asian community, that this is impacting other people who are foreign-born, who are brought here to this country as well, and that for us to ensure that everyone has due process in with this particular change. So I appreciate the bill, and thank you for bringing it forward.
Thank you. Representative O'Neill.
Thank you, Mr. Chair. As I'm just reading this, again, I just want a clarification on something, especially on the public record, to kind of help this case move along. But if the author of the bill, if Chair Mariani would help, in line 2.8, it says that the result of a conviction that was obtained relying on incorrect advice or absent advice from counsel. So that is privileged private information between the client and the lawyer or the counsel. So can you just kind of walk me through how that would be substantiated in a court of law to prove that the advice was either absent or inaccurate?
Well, I think that the short answer is, Representative O'Neill, that advice does have to be on the record. is currently on the record. And if it's not, if it's absent of the record, that's a major issue, but maybe Professor Chan has a better answer than that.
Yeah, this language was specifically used to sort of mirror what happens now in a Padilla-type proceeding. So in Padilla, currently, since 2010, the Supreme Court has said it would be a violation of the Sixth Amendment if a person got incorrect advice. And so that process already happens right now for people filing post-convictions within a 2-year window. They would need to prove that they got incorrect advice. I won't speak too much on how, but it could be anywhere between using attorney notes because the confidentiality is with the client, not with the lawyer. The client could, of course, release all confidential communications, including perhaps affidavits, notes, but that would be something that they would be required to do under the statute.
Thanks. And that was also just helpfully clarified by staff that the privilege is the defendants, not the lawyers, so, okay, you get that then. Thank you. There being no other comments from the committee and no one else from the audience or public who wishes to testify on House File 3975, the motion from, well, motion from Representative Mariani is that House File 3975 be recommended to be placed on the general register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, everyone. You're on your way to the floor.
Mr. Chair, and I want to thank the committee for a very good, thorough conversation, and Representative O'Neill and others. I'll certainly be tracking the fiscal note and circle back with you as well. Thank you, Mr. Chair.
Thank you.